All right, this matter, People versus O.J. Simpson. Mr. Simpson is now present again before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey. People represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. We have a number of matters to take up before we begin the pre-instructions and opening statements. Counsel, first matter is the motion to quash the subpoena for Marguerite Simpson Thomas. Mr. Jones is present on behalf of the purported witness, and Mr. Hodgman.
I'll be addressing that matter on the part of the people.
All right.
Carl Henry, Your Honor, appearing on behalf of Attorney Jones if he's required to testify.
Your Honor, with regard to that matter, first of all, I will not be seeking to examine Mr. Jones. I spoke to him yesterday, and for purposes of the record, I don't think that's necessary. However, we will be asking that this matter go over to February the 1st at 4 p.m. at the conclusion of the jury proceedings for the day.
And why is that?
And why is that? Because basically in an effort to be able to resolve the situation more expeditiously than with a full-blown hearing. And I've been speaking with Mr. Jones. I'm going to be handling this motion on the part of the people, and it may be through proffer so we can simply get this resolved by this court in a more expeditious fashion.
All right, Mr. Jones.
Your Honor, we did speak yesterday, a Sunday. I was working. I had requested. I had requested a Friday that was inconvenient for the people, and so we arrived at the 4 o'clock setting as a compromise, if that's convenient to the court.
All right, then we'll...
I would estimate, excuse me for interrupting, that I do have one witness, and I would estimate approximately 45 minutes total for the motion, which would carry us to 4:45 or thereabouts.
All right. All right, then on the prosecution request, this matter will be continued to February the 1st at 4 p.m. and the bench warrant, the body attachment previously issued and held will continue to be held to that date and time.
Thank you very much.
Thank you, counsel. All right, counsel, we also have some other items regarding instructions. Ms. Robertson. All right, counsel, on the proposed instructions, pre-instructions that the court is going to give, I just wanted to put a few things on the record. The court's instructions include 4.50 Calgic alibi, also include conflicting experts weighing conflicting testimony, which assumes that the defense will be presenting a defense. So not waiving, understand that by agreeing to those instructions, you are not waiving your right to make an 1118.1 motion, but assuming we get to that point, I take it that's agreeable to the defense.
That's agreeable, Your Honor.
All right. Also, or 2.61, defendant not testifying, and any assumption or inference to be drawn from that fact. What's the defense position on that at this time?
At this point, we're not asking for instructions.
All right. All right. I also understand that there are a number of objections the court needs to rule upon concerning the exhibits, proposed exhibits for the opening statements, correct? All right. Excuse me just a second, Mr. Hill. All right, Mr. Douglas, you going to handle this part of it?
Your Honor, yes. Mr. Coach,
Sure. All right, counsel, let me advise our evidence presentation people that there is an objection to perhaps 10 of the exhibits that the prosecution wishes to present during the course of opening statements, I need to view those here on my monitor screen. What do you suggest I do as far as, because these are not for dissemination at this point? Can we accomplish that, Mr. Reitman?
Yes, the county sees them as well on their monitors.
I believe so.
Then they can bring them up whenever prosecution's ready, and it will just be on those 3 monitors that you see right before.
Fine.
Your Honor, do you want those on the table monitors as well, or simply?
We can shut those down as soon as.
All right, I'm also going to direct the still photographers not to attempt to take any photographs of the court's monitor, as well as the TV camera.
But you'll also have to cut the video feed from our system out off from your system.
And Judge, with regard to the table monitors, you're the only one that really needs to see them, Mr. Rice.
Correct. All right, I see what appears to be an alleyway in the back of a building. Is this a test photo?
Did the court not want them to be shot up there?
That is correct.
They should not be shot up there, right?
That is correct.
Right. Yes.
Here.
Say what, Your Honor.
All right, what is the people's identification number of this photograph? All right, next. All right, what's the people's identification number?
P35.
All right, next. All right, and what's
P113.
113?
Yes, Your Honor.
Next.
P44. And here's one that I think, I'm not sure whether Carl and I talked about it Saturdays. So I'm going to show the court and counsel now, whenever the court wants.
All right, next.
That's P417.
All right. Next.
I need to make sure you're on
All right, counsel, is there a particular reason we need to hear this argument at sidebar? It's a 352 objection, essentially. All right. For the objection of the defense as to these 5 items, Mr. Douglas, you indicated there is no objection to People's 417, which is the photograph of Mr. Simpson's hand, correct?
That's correct, Your Honor.
All right, so the objections are to the other four. Ms. Clark, I'll hear your argument as to People's 40.
I'm sorry, 40.
40.
Yes, with respect to People's 40, let me first preface my remarks with this, Your Honor. We had shown Mr. Douglas,
Excuse me.
Your Honor, when I was shown the photographs on Friday, I was shown a larger series of photographs. Given that this is the one photograph of an extended series that they are going to offer, I would not object to that one.
People's 40.
Correct.
All right. People's 35.
I do object to that one, Your Honor.
All right. Ms. Clark?
yes, Your Honor, actually, this is a far less gory photograph than many of the others that people have, and the value of it on the 352 is clearly shown, the probative value that is. We are showing evidence in its relationship, locationally speaking, to the victim, the manner in which, the spatial connection between them, and the position of the items of evidence in relation to the victim, so that we can show how close and narrow the area is, the positions of each of the victims, and the position of the evidence vis-a-vis those victims. And the court can see that that is exactly what's being pointed to in that photograph. So the probative value clearly outweighs any prejudicial effect. I'd like to cite the court as well to the case of People versus Pride, 3 Cal 4th, 195.
Which stands for what proposition, Ms.
For
Clark?
the admissibility of the videotape, and, excuse me, Your Honor. People versus Sims, 5 Cal 4th, 405. Both of the cases cited, that I decided to report Pride and Sims address the issue of videotape as well as gruesome photos for the purpose of establishing relevant facts in the case. In this particular case, the people had weeded out numerous photographs that were extremely graphic in nature in favor of the more minimalist approach of taking photographs that were the least graphic in nature, but still conveyed the message in an evidentiary sense to indicate what we needed to in terms of the information that we're trying to give to the jury. So the photographs that the court sees is even less than what Mr. Douglas was shown on Friday, because Mr. Douglas indicated there would be objections to too many of the photographs that the people felt were nothing more than illustrative of important information and certainly not unduly graphic. But we even cut back from that. So what the court is seeing here is the most minimum, is the very barest minimum that the people need to show to explain to the jury where evidence was located and where the victims were found, in what position and in what relationship to each other.
Mr. Douglas is obviously going to argue that we could depict that by a diagram without having a bloody crime scene photo.
We really can't. That's the problem, and I think the court is aware of it. This crime scene is very difficult to depict, even in photographs, and we're going to have jury viewing for that very reason. But photographs are certainly better than a diagram. We tried to depict it in the diagram, and it doesn't explain, and it doesn't show the jury clearly enough what we're trying to convey to them. And there's nothing that is more explanatory, nothing more readily acceptable or understandable to a jury than a photograph. That's why we have them. That's the purpose of them. Diagrams can only convey so much, but the actual item itself, a photograph of it, is much more informative. It's simply more informative than a diagram. We do attempt to use diagrams as well, but it simply does not have the force and impact that a photograph does. That's why counsel's objecting to. That's exactly the point, Your Honor. If a diagram was as good as a photograph, or was the same as a photograph, counsel wouldn't object to the photographs. The point is that the people are trying to explain something to the jury, and we need to do it in the most effective way possible. Not only that, Your Honor, I will say this. We have shown, well, the photographs we're using are really the most minimal in terms of graphic impact. Nevertheless, the people's position is that we would be entitled to show photographs far more graphic than this, and it's because it is relevant to malice and to intent, which is obviously what the people have to prove in this case. So this is the very most minimal impact. We also have shown in...
All right, Ms. Clark, would you address People's 113, the photograph of Ronald Goldman?
That is truly, I don't know why I wonder if the defense is really still objecting to that. That is the only depiction of that victim. And it's a far-off shot. It's about as minimal as you can possibly get.
Well, it's not far off. It's a full frame.
It's full frame, but there are closer shots
Depiction.
that the counsel is aware of that we could have used and did not. So I'm going to ask to see if counsel still objects to this. It's the only depiction we have.
Your Honor, if Ms. Clark is saying to the court that that will be the only photograph of Mr. Goldman or the Goldman body that she is going to be using in her opening, I respect that, and I would allow that one photograph to be used.
All right.
But I do think, Your Honor, that the Exhibit P35 as well as Exhibit P44 are far more prejudicial.
Hold on. Let me hear her comments.
And then, Your Honor, there are other photographs that I was reminded that's another question.
All right. Ms. Clark, People's 44, what's the relevance of this particular photograph? What's the relevance and necessity of this photograph?
With respect to P44, we have part of the evidence in this case, the very important evidence in this case, are the bloody shoe prints. There's one set of bloody shoe prints leaving the scene of the crime, going back to the rear alley. And the blood that the defendant stepped in to create those bloody shoe prints is very important evidence. We need to show, with respect to this photograph, we show not only the blood that was stepped in, along with shoe prints that are depicted in this photograph, but the closeness of the envelope to the body. So it's a perspective shot showing showing again an array of evidence, not just one thing. So this is a different view, showing a different perspective and showing different evidence vis-a-vis the victim. And also, I would indicate that P44 shows the back of the victim, which is far less prejudicial than the view from the front. So none of these are duplicative. You know, every single photograph that I've talked about shows a different view of each of the victims with different items of evidence that we attempt to depict and demonstrate certain information to the jury.
All right. Mr. Douglas, your response.
Your Honor, I recognize that this is a murder case, and with murder cases there are dead bodies. I do think, however, that the court needs to balance the prejudicial impact, the emotional sense that many of these pictures will engender in the jury. Certainly, I think it interesting that the reason why the people would rather have a photograph than a drawing, and I'll represent to the court that there are drawings which show the interrelationship between the two victims, and there is very capable for Ms. Clark or whomever to describe, based on that schematic drawing, where the envelope was, for example, where a glove was found or whatever. I think the reason why they want to show the photograph is to give some emotional texture to the jury, to Mr. Simpson's detriment, and I object to that. And I think, Your Honor, that both pictures P35 and P44 are cumulative when taken together. Both show a view from above Nicole Brown Simpson. Both show her laying in a fetal position with there being blood flowing down the walkway. I think certainly either picture is adequately capable of exemplifying the setting that Ms. Clark wishes to offer. And I do not think it necessary that both be offered into evidence
All right,
or
may I
even
s-
used for opening statement.
All right, may I see 35 and 44 again, please?
Okay, and I'd like to further address the court if I may, after those are seen.
Now, it sort of works.
Well, because, Your Honor, there's something else the court needs to bear in mind. Diagram cannot depict.
Counsel, counsel, please. All right, let me see 44. All right, thank you. All right, the objections will be overruled. Both those photographs, 35 and 44, depict different items at the crime scene. It's clear to the court that the key issues, at least as the crime scene is concerned, is the collection of evidence and where that evidence was, so the objections are overruled.
Your Honor, there are at least two, if not more, other photographs that are going to be offered, which is part of a video graphic. They are, in particular, photographs of criminalists Fung and Mazzola using the pheno process on the drain in Mr. Simpson's bathroom, in his shower, and particularly on the basin in his bathroom. I remind the court of the court's earlier ruling that the pheno testing in and of itself would not be admitted into evidence unless there was further corroboration that was going to be offered. As it concerns the drain in the shower, as it concerns the drain in the basin, I do not recall there being any presumptive or supplemental test to corroborate the presence of blood in both of those locations. As the court is aware, hairspray, lemon juice, fruit juice, a host of different other matters that are certainly innocent, are capable of registering a positive showing on a pheno test. And what you're going to have is, you'll have, for example, a video picture of the bathroom honing in on the drain, and dissolving from that will be a photograph of Fung showing a Q-tip leaning down at the drain pipe, and a similar presentation of the photograph of Mr. Fung leaning down at the basin in the bathroom. I think consistent with the court's earlier rulings, those two photographs or any depictions that show the phenotyping that is not corroborated by other testing methodology should not be offered in the opening statements.
All right, are there any other objections to the people's exhibits?
No, Your Honor.
Ms. Clark?
I understood the court's ruling to be that luminol would not be admissible without corroborative evidence. And
That's my recollection.
yes, the phenol test is a different story. That's been admissible from, I can't tell how many years ago. It's limited in its value in terms of what both sides can argue about it. It indicates the presence of blood. That's all it does. We're not saying it does any more than that. And the photographs that counsel is complaining of are photographs showing the pink color on the pheno stick that indicates the presence of blood in three areas actually in the defendant's bathroom. As
All
I
right,
understood the court-
are these still photos, excuse me, Ms. Clark,
Mhm.
forgive me for interrupting you, are these still photos or video?
Still.
All right,
Still, we're not going to be, I think we have cut out all of the video that we were using. These are still photographs that counsel has had in discovery for a very long time. And in my understanding, since it really pertained to luminol and not the phenol test, I thought there would be no problem with this.
Your Honor, the problem is that 99% of all homes in America, if there was a pheno testing on their shower drains or on their bathroom basins, would register positive for the presence of some sort of blood. And the problem is, in this case, there has not been, and there will not be, as far as I currently am aware, any supplemental follow-up testimony suggesting that, in fact, based on further testing of both the shower drain and further testing of the bathroom basin, we now believe that there was blood that was recently washed down that basin. And therefore, Your Honor, you have another 352 problem. They are going to simply traipse around on the screen that there is a gentleman doing a phenotype, and they are not going to corroborate that or supplement that with other testimony, expert or otherwise, to show that after this photograph was taken, we took out the pipes, we tested the pipes, and we saw, in fact, that there was blood. And in fact, this blood is recent blood and not blood that was there from a day earlier, or a week earlier, or a month earlier. So I think, Your Honor, given its present form, it is terribly misleading in the opening statement, and I'd urge the court to exclude it.
Ms. Clark?
Well, Your Honor, I would not object to going back to counsel's house right now and testing the drains to see if that's possible, but I don't think that everyone's house drains will test positive for the presence of blood at any given time. However, we have heard counsel's argument that's the limitations of the test. He's correct, that we cannot say when it was deposited. However, when you have traces of blood, and that's what this was, there is no further testing that can be done because there isn't that much. It will wash down with water. That's the purpose of washing it down the drain, is to wash it away. So we had traces of blood in the drain at the shower and the bathroom, and there was a trace of blood on the floor as well. The counsel's argument goes to the weight and not the admissibility of this evidence, and the counsel is fully entitled to argue everything that he just has to the jury.
All right.
Your Honor, my learned colleague, Mr. Ullman, reminds me that a pheno test is the same as a luminol test. It is a presumptive test. It is not a test that corroborates the presence of blood. And since it is a presumptive test, it is susceptible to all of the dangers of misinterpretation that a luminol test would be problematic with. And therefore, Your Honor, by analogy, the reasoning that the court had held with the luminol test should hold firm for the pheno test. There were some areas, Your Honor, where there's a pheno test done of blood on the foyer, to which I'm not offering an objection because there was independent collection and independent verification of the presence of blood. Not so with the bathroom drain, not so with the bathroom basin, and therefore I am limiting my objections at this phase to those two areas.
All right, counsel, the problem with the dilemma you present to the court is that we're talking about conducting another 402 hearing as to this issue, which I'm not inclined to do at this point today. Counsel, my inclination is to direct the prosecution not to use those two items in opening statement subject to a 402 hearing on the pheno testing. All right, that's the court's order. All right, any other show and tell objections we need to resolve?
None by the defense, Your Honor.
All right, now, the prosecution indicates that they have not had complete access to your exhibits for opening statements, Mr. Douglas. Are those exhibits present in court?
They are, Your Honor.
All of them?
Graphically and in board form.
All right. Then I would suggest it would probably be a better use of the court's time to take a brief recess, allow counsel to look at these items, and then lodge any specific objections. All right. We'll stand in recess then for 20 minutes.
Thank you, Your Honor.
All right.
Your Honor, can we have the monitor people turn on counsel monitors so they can...
Yes.
And can you have a seat?
That they had no further discovery to give us and that they were in full compliance. Clearly they were not. They were not in full compliance by any stretch of the imagination, neither with respect to the exhibits, nor with respect to the videotapes that they had, nor with respect to witness statements that were taken. This is, I'm absolutely shocked. I am shocked at this kind of conduct. You know, how could they withhold all this material and claim, and yet come into court and claim to this court on the record that they were in compliance with the discovery order? Not only are they not in compliance, they're in willful non-compliance with it and had made material misrepresentations both to the court and to counsel in this matter. How can the people possibly get a fair trial when defense has willfully withheld information, preventing us from preparing the case, and at the last minute springs things on us, knowing full well that they've had them for such a long time? There is nothing fair in what's been done here. This is willful noncompliance with a court order and a willful desire to deprive the people of the state of California of a fair trial. The people object to all of this, not to mention there are specific objections to many of the exhibits, but I think that this noncompliance is something that really has to be dealt with. And I'll tell you, I'll be honest with the court, you know, I've never seen this kind of conduct on the part of defense counsel before, never.
All right. Ms. Clark, may I see that list, please? No. The what appears to be labeled a defense supplemental witness list, which appears to contain certain witness statements and a long CV for Dr. Lenore Walker. What remedy are you asking for? far as the discovery issue is concerned.
We would request that the defense be precluded from calling those witnesses, as is required by the Penal Code Section 1054 et sec, for willful noncompliance with court orders. I would also cite to the court defense counsel's response to the people's motion made in December for sanctions for noncompliance, and in that motion, the defense filed on December 30th, it stated that the defense has fully complied with the requirement to disclose witnesses and statements, and that is not obviously the case. I would ask the court further to order that counsel turn over all of the statements and all of the investigation that they have prepared to date today, now, before we begin opening statements, and further that there be no mention of anything contained in this late discovery in opening statements today. That includes, of course, videotapes, photographs, any other graphic depictions they intend to use. Obviously, the videotape, which was turned over only today, which they've had for quite some time, is an example of that sort of thing. The photographs that the court sees right here, blown up on the boards, were never shown to the prosecution. So we would ask that all of that be turned over forthwith before we begin opening statements, and that there be no mention of anything that they've turned over today or will turn over pursuant, I hope, to the court's order in the opening statements as well.
Mr. Douglas?
I may also include, Your Honor, any tapes of interviews that were conducted as well.
First of all, Your Honor, the court is mindful that the obligations of a defendant under the state's discovery rules differ from those of the prosecution. However, let me make a couple of things perfectly clear. We have continually been refocusing and re-strategizing those individuals whom we intend to call for trial. Many of the individuals who have been added on our supplemental witness list are decisions that have been made only since the court's rulings on the domestic discord motion, as well as the court's rulings on the Furman motion. You were given a packet today, Your Honor, and Ms. Clark made clear to hold up the packet, but that packet contained 34 names, 6 witness statements, and 34 pages of the resume of an illustrious expert, Dr. Lenora Walker, who only on Sunday had preliminarily completed her review of the evidence in this case and had committed to working on behalf of the defense in this case. She has not yet even authored a final report. We have not yet, for example, seen any of the data. As the court is aware, Dr. Walker visited Mr. Simpson within the last month, 3 weeks for sure, and the decision to call Dr. Walker hinged on the court's ruling on the domestic discord, on the court's ruling of the admissibility of Dr. Dutton, and after consulting with Dr. Walker this weekend, only were those decisions made. Secondly, Your Honor, in terms of the discovery of videotapes or that kind of thing, when we asked in the beginning of this case for news reports or for hospital records or items that were equally available to either side, the prosecution's response, quite pointedly, and the court agreed, was, if it's a newspaper and you can subpoena the paper, you do it yourself. And thereby we did do it ourselves. We went out on our own and simply obtained news documents or news footage that we decided to use in our opening statement. Your Honor, we were in the office, 10 of us, until 2 o'clock, I left at 1:30, until 2 o'clock Thursday night, going through these graphics, trying to make some decisions, and those decisions were not yet completed. Your Honor, I was in the office.
Counsel, we're mixing apples and oranges here. I'm interested in the discovery issue first, why this list is now being made available to the prosecution this morning, first of all, and then secondly, what is your response to the prosecution's request that I preclude the testimony of everybody who's on this list for failure to comply with the court's previous discovery order? That's the issue. I'm not interested in these charts right now.
Very well, Your Honor. Decisions, I speak to the charts because decisions on witnesses that we were going to offer in evidence were not finalized until this very weekend. We have been spending the bulk of our time running down the over 350 names that we have been given by the prosecution's list. Now, Your Honor, we have attempted to try and interview witnesses that are on their list, but that is not discoverable under the discovery rules. When we are interviewing their witnesses for impeachment purposes, that is not discoverable. These are names that were added that were not on the prosecution's list, that were decided after the critical rulings on domestic discord and on the Furman motion, and that were decided after talking with Lenora Walker and those individuals that might be able to provide some context, if you will, to some of the allegations that the court is going to allow to be admitted. And therefore, Your Honor, we have fully complied with the defendant's obligations in the Discovery Act. If the court will recall, assuming we have presented these 34 names today, there is still at least an additional 2 months, even under the most conservative of estimates, for the people to go about doing their work, attempting to interview witnesses that are on our list. One thing that is interesting, however, and you hear all the screams and all the protestations by Ms. Clark, with all due respect, there are names on our first list that we submitted August of 1994 with addresses, with phone numbers, who were never contacted by anyone on behalf of the prosecution, even up until this very day. We are continuing to make decisions. We are fully complying with our obligations under the code. Now, as for sanctions, Your Honor, I think it very ironic that the people would stand here and seek the sanction of exclusion, the ultimate sanction that the court is empowered to impose, given all of the equities of this case, given the background of this case, given the fact that when we were given a list of 206 names on January the 6th on a trial that was due to start 2 weeks later, our only sanction that we were seeking was simply give us more time, require them to not offer these names in opening statement, require that they change the order of proof and put the proof at the end so that we would have enough time to adequately prepare in response to this evidence. I dare say that we had the possibility of seeking the ultimate sanction of exclusion, but we did not go that route. I would urge the court to not go that route here. I think, Your Honor, given where we are in the case on the first day of opening statement,
We may not get there today.
well, on the first day scheduled for opening statement, and the defendant has supplemented their list of 34 additional names, that the prosecution is not unduly prejudiced, that the prosecution will have more than adequate time. They have the entire 8,000-man police force, man and woman police force of the Los Angeles Police Department at their disposal. They have the 600 lawyers employed by the district attorney's office. 900 lawyers, excuse me.
900.
They have far more resources than we, Your Honor. Their prejudice thou protest too much when you consider the equities that are involved in this case. And certainly, I don't think, Your Honor, that the sanction of even excluding these names from our opening statement is one that has to be imposed. And with the exception of Dr. Walker, who I think Mr. Cochran perhaps may like to mention in his opening, I am not sure even that there's even going to be an attempt to discuss these particular witnesses, perhaps as well with Ms. Bell. But I don't think that there's much of an attempt to offer these witnesses during the opening statement. But even if that is the case, it would not be a fair sanction given the posture that we've had in this case, given that we are on the first day scheduled for opening statement, given that this is a case where even the prosecutor estimates that their case is going to take at least 8 weeks, if not longer. There is adequate time for them to prepare. They have not even done work on other witnesses whom we gave them back in August, Your Honor. And I don't think that their protestations should be taken with any great weight by this court.
Mr. Heitman, briefly.
Yes, Your Honor, thank you. Once I stood before this court and indicated that I was slow to anger, it comes a little more quickly this morning. Your Honor, I had to brace, if you would, Mr. Douglas to even get the list that is now before the court. When would the people have gotten that had I not spoken to Mr. Douglas and said, after I have seen photographs, which obviously have been in existence for some time, which obviously they've anticipated using, and I see this and I think, where is our discovery? Where is the reciprocity of discovery? And it was only then that this witness list comes up. And, Your Honor, when would we have seen it had I not asked Mr. Douglas, asked the defense for that information?
How firm
In
are
it-
the people, how firm are the people they're requesting preclusion as a sanction?
Very firm. Just one moment. Your Honor, we'll withdraw the request for preclusion on the condition, if the court will entertain this, that the sanctions regarding our witness order, when we provided our witness list well in advance of trial, be lifted. That's what we would like to have from this. They can call their witnesses in their case if they wish, but remove from us the sanction that the court imposed in terms of when we provided a witness list well over a month before today's date, well over a month. And even then, Your Honor, I don't intend to re-argue this, but the witness list aspect was actually more of a form over substance type thing. However, that is what the people proposed. In addition, I would like to simply state that Mr. Douglas addressed asking us to go out and obtain news footage, news video, and the like for them. We're not investigators for the defense. They had access to it. The difference is, and the distinction is, Your Honor, they have elected to utilize it. They have collected it, and now they intend to use it. Where is the reciprocity of discovery? This is being popped on us on the morning of opening statement.
All right, Mr. Hodgman, let me ask you this. Of these 34 names, several of these names are very familiar to me. Others, I have no idea who they are. For example, I'm acquainted with Willie Williams and Dr. Walker, of course. But as to each of these, I mean, are you raising a blanket objection to all of these? Certainly you know who some of these people are. You've anticipated what their testimony is going to be. Their appearance on the defense list is certainly not a surprise.
Well, I've been surprised in more than one way so far this morning, Your Honor. However, right now, the court...
Excuse me, Ms. Clark, is this your only copy of this?
It is.
Mr. Douglas, how many copies of this package do you have?
I have an extra one.
Thank you, Mr. Douglas.
Let me just have my, Chris? Mr. Hodgman, while I'm waiting for that photocopy, doesn't Mr. Douglas's argument, though, that these decisions to whether or not to call these witnesses hinged upon the court's in limine motion rulings? And obviously their strategy changed in light of the court's rulings?
Your Honor, I know the court has had an opportunity itself to examine some of this. When I look at a memo dated June 27th, 1994, which did not, as far as I can tell, have hinge in any fashion, have any nexus with the court's hearings, our ruling, and we get this today, I just don't know what to think.
Let me indicate that under that theory, we would not have had to disclose any of the domestic violence witnesses to the defense until after the court ruling either. I mean, if we're going to wait to give discovery of witnesses that may be used by either side until the court makes a ruling, then I suspect that there would be a lot more witnesses that the people would not have had to disclose, and nor would the court have imposed any sanction for late disclosure. That simply, the argument proffered by Mr. Douglas in that regard should be unavailing, because if they have these witnesses, they know these items are an issue, then these are people that they may call in trial or intend to call in trial, and we should have discovery of them.
All right,
And then
counsel,
they may not be
let's-
called based on a court's ruling.
Let's take it from the top. Who are you surprised by on this list? Let's take the first name.
Your Honor, can I try to offer an explanation as to each of them?
No, I just want to find out who we're fighting over. There's obviously some of these folks we're not going to fight over, and others will have to. This
Very
is an
well.
individual, witness by witness, determination.
I'm sorry,
Yes.
Your Honor. Can we get more than one copy of this
Sure.
document?
Mr. Darden, once you approach, let me give you a couple extra copies here.
Could we as well, Your Honor?
Certainly.
Your Honor, could you give us some time to read this, please? I mean, we can't stand on one foot and read all the documents and answer the court. Could we get at least 15, 20 minutes to read everything and see see what we have here?
Your Honor, there's
I mean, that's the problem with this. We're surprised by it because we've never seen any of this. We don't know. We see names we never
Well, if you
recognize.
see it, well, that's a signal right there. If you don't recognize the name, let's take it from the top. Let's see how much progress we can make.
But we need to read it first, Your Honor. We need to
Counsel,
read
you
it.
have it right in front of you. Kathleen Bell, number 1. Not a surprise. Correct?
There's no witness statement.
There is a witness statement. If you read the package, there's a witness statement by her. There's a report from Mr. Pavlik regarding a telephone call from Kathleen Bell in the package. Is that a surprise to you?
I don't know what it is. I can't tell until I see it. This is redacted.
Yes, it is.
Well, we heard about that. I don't know what's in the redact, they blacked some portions of this statement out.
All right, have you seen this statement before? Yes or no?
I have never seen it.
All right, so that's a surprise to you? I think that's a redundant, rhetorical question if you haven't seen it before.
Certainly,
All right.
the witness isn't a surprise, Your Honor.
Obviously, the witness is not a surprise. Another statement by the witness that they've never seen before is a surprise on on today's date.
Very well.
All right, Rachel Berman.
There is no statement.
We don't even, so they're not even giving us a statement already.
There is no statement.
Do you know who,
Then how do you know you're gonna call it?
wait. Counsel, please. Who is Rachel Berman?
She is the daughter of a neighbor and former friend who accompanied the children to the recital on the night or the day of the murder.
All right, is this name known to the prosecution?
Pat Berman, the mother, is on their witness list, Your Honor.
Is this name known to the prosecution?
No, I'm not familiar with Rachel Berman.
All right, Dino Bucola, and my apologies for anybody whose name I mispronounce. Do you know who this person is?
No, that's totally unrelated.
It goes directly to the domestic discord ruling and a witness who will contradict allegations proffered by the people.
Which incident?
The Red Onion incident.
Where-
Do we have a statement?
No statement in here.
There is no statement.
I
So you know these people are relevant, but you have no statements by them.
Correct, Your Honor.
You have no reports to turn over.
Correct, Your Honor.
You expect me to believe that?
Your Honor, it's the truth. Your Honor, there
How
are
can you
people...
How can you have no statement, no recollection, no recordation of what these people say?
For example, Your Honor, if Mr. Simpson tells me that there's a certain person who knows about a certain incident, and I call the person up and take notes of that person and I add his name to the witness list, there is no discoverable statement generated by that interview. There is no investigator who has interviewed Dino Bucola who has a statement that I would turn over to the people. My statement or my rough notes are my attorney work product, Your Honor, respectfully, which are not...
But actually taking witness statements is a different issue.
Taking a witness statement is when I write down what he says and and he signs it, for example. That is not, there is no such statement in evidence or in our possession.
I believe that there's a case right on point concerning
Yes, there
this.
is. Yes, there is.
And counsel's incorrect in the statement of the law and his
I'm aware of
obligation to disclose.
Your Honor, when the court ruled on the domestic discord, attorneys then went to interview Mr. Simpson about the court's ruling. Attorneys then went to discover or to identify individuals whom they intend to offer or who they reasonably intend to offer in response to the court's rulings. We have, with Dino has not been interviewed by any lawyer, but I'm just saying, for example, we tried, as soon as we made a decision based on the court's ruling, to identify individuals such as Mr. Bucola who we reasonably intend to call as witnesses. Because Mr. Simpson says this person is someone that we can call who's going to contradict something else that they're going to say, and that name was added to the list. That is why there's a name added to the list. There's not an address for his name, and there's an office phone number.
All right, Randy England.
I've never heard his name before on this. Is there a report on this? There's no report here.
No.
There's not even a statement.
He is a person in their notes, Your Honor, who they had on their list concerning the Trist incident.
Mr. Jordan, who has been investigating domestic violence matters, does not recognize that name.
He was a witness who was in Trist.
Was Mr. England listed in any of the prosecution's documents?
He was not.
All right, Nancy Janusa.
Before we leave Mr. England, Your Honor, we don't have a telephone number, nor do we have an address.
Counsel, the list is apparent to me as well. All right, Nancy Janusa, who is this person? First of all, are the people acquainted with this person?
No, we're not, no.
She is a Los Angeles Police Department employee working out of the property division.
All right, and what's her role in this?
Where's the statement?
We have not interviewed her, Your Honor. She's an LAPD employee.
All right, and what is her involvement in the case?
We believe that she is one of the chain of custody witnesses. But what we're doing, Your Honor, so the court also understands, is in our efforts to be overly inclusive, we are taking names that may have been on the prosecutor's list, such as Ms. Janusa, and adding them to our list in the event that the prosecution withdrew their names, such as the 83% of the names that were withdrawn. We wanted to make sure.
Counsel, you're wasting my time at this
Very
point.
well.
I just want to know who these people are.
Very well.
All right, Larry Glorioso.
All that I know is that he's an LAPD employee, Your Honor.
And what are we going to, why is his testimony potentially relevant? Let me ask the people if they're acquainted with this name.
Yes, people are acquainted with this name.
Okay, then we'll pass this one. Richard Green.
So we've never, this is the first we've ever heard the defense attorney call.
All right.
Mr. Green is an employee of Vertels, Your Honor. There is no statement. He has not been interviewed.
And we've never heard of him.
All right, Dr. H. Range Hudson.
Dr. Hudson was only retained last evening, Your Honor. He is a cut expert. He will testify about the...
All right.
No?
And Susie Kehoe.
She's a personal friend of the defendant, Mr. Simpson. And Nicole.
Statement?
None has yet been taken.
All right, David Keith.
Personal friend of the defendant. No statement has yet been taken.
Tawny Katane.
So that Mr. Keith is the witness to the Trist incident. Tawny Katane is a personal friend of the defendant. No statement has been taken.
People acquainted with Tawny Katane?
Well, we know the name, but there's obviously no statement. There's no address. We don't know what should be relevant to.
All right, Steve Leeds.
Steve Leeds is an individual that is known to the Brown family.
First we've ever heard this name, and what is she relevant to? Steve Leeds. There's no statement here.
All right, Louis Marks.
Louis Marks is the friend of Mr. Simpson, who owned a residence in New York City. That is one of the incidents that the court allowed admission in.
I don't recall a New York City incident.
I recall a New York City incident in 1977.
Perhaps it wasn't admitted, Your Honor.
You excluded that incident.
Character witness then. He has not been interviewed. There's no statement that we have in our possession.
Counsel says a character witness?
Correct.
All right, Ed McCabe.
Did the court skip Scott Matsuda?
Yes, I did.
Ed McCabe, Your Honor, is...
No,
one-
I did that inadvertently. Tell me about Scott Matsuda.
Scott Matsuda is an employee of West Tech Security. We have not interviewed him. There is no statement.
All right, Ms. Clark?
Yes, Your Honor, we are familiar with that.
All right, Ed McCabe.
Ed McCabe concerns one of the incidences on domestic discord that the court allowed the admission. There is no statement. There is a statement? There is a statement in the file. January 17th was that
Where's the
statement. It's in the packet. January 17th.
All right.
Your Honor, there's an entire first paragraph blacked out in this statement.
Well, that's another issue,
All right.
counsel. All right, Sergeant Marin, West LA Watch Commander. I take it on the AWC,
I'm sorry?
Assistant Watch Commander.
Correct.
Lieutenants are watch commanders. All right. I take it you're familiar with this name, Ms. Clark.
From a clue that we got from the People's Discovery.
Sergeant Marin?
Yes.
Correct.
No? I've never heard the same. I don't know.
There's a clue concerning the People's Discovery, and his name was added as a precaution.
I have no idea what else is talking about.
All right, Tony Parker. Ms. Clark, are you familiar with this name, Tony Parker?
No, Your Honor. And I don't think there's a statement there.
There's not a statement, Your Honor. Can we come back to that one?
Yes. All right, Dr. Harvey Paley.
Yes, Your Honor. That concerns an incident that was mentioned in the discovery materials. Correct. And the court ruled about, the court excluded it last week, but we're leaving him on as a precaution. There was a matter concerning records.
Yes, okay. That one's a who knows. Okay. Claudine Ratcliffe, I'm sorry.
Are you thinking of Dr. Alford in the 1986 incident?
No.
No, this is Dr. Harvey Paley.
There was a hearing in front of Judge Oderkirk last week.
This is a subpoena on records.
Correct.
That's there as a precaution. All right, Claudine Ratcliffe.
That's
We're
it.
familiar with Ms. Ratcliffe. Do you have a statement on her?
No. We haven't interviewed her.
All right, Rolf Rokar.
He's an LAPD photographer, Your Honor. We
And
received
I recall seeing his name in one of the motions recently.
just recently.
Tracy Savage.
There was a decision to add her to the witness list to authenticate certain theories that we are offering.
To authenticate theories.
She is going to authenticate a report that she gave.
Okay. The infamous report.
Correct.
All right. I take it this is no surprise to the prosecution.
Well, if they're going to call Tracy Savage, yes, it is a surprise, of course.
All right, but you're familiar with Ms. Savage and the issue that's raised.
Oh, yes.
All right. Lawrence Schiller.
Character witness, Your Honor.
Do we have a
10-year friend of the defendant.
do we have an address, phone number?
All right, Mr. Darden, we'll take up those issues yet. The actual who they are, where they are. The issue is it a surprise to you and what they get to use in their opening statement and what they don't?
Perhaps the court did answer that inadvertently, but I think the court skipped Lawrence Schiller, who is also...
Character witness.
That's what I just
Oh, I'm
asked.
sorry. Unknown to the people.
All right, Ron Ship.
On the people's witness list, Your Honor.
Does the defense have any statement from him?
No, we do not.
All right, Dr. Geraldine Staley.
Geraldine Black Staley is an assistant to Dr. Walker.
I need to ask the court indulgence, Your Honor, with respect to Matsuda. Counsel indicated there was no interview. We know that there was by investigator Kaplan.
I will check then. It's news to me.
We do not have a report of that interview.
All right.
The interview was conducted months ago.
I'll check.
All right, what about Dr. Staley? Are you acquainted with that name, Mr. Darden?
No, Your Honor.
She deals with the domestic discord issue.
All right, Mark Stevens.
He is the trainer or former trainer of Mr. Simpson, and we've recently decided to add his name.
Physical trainer?
Correct.
Personal fitness trainer?
Correct.
All right. I take it. Ms. Clark, are you acquainted with that name?
No, Your Honor.
All right. Officer Thompson, West LA.
I'm not sure of his role, Your Honor, but several lawyers got together to develop this list, and we added it as a precaution.
Are you acquainted with his name?
No, no, I'm not, Your Honor. But with respect to Mark Stevens, I'm reminded that there was, Detective Lang informs me that there was a brief statement taken, but not as it pertains to his involvement with the defendant. It pertained to his ownership of his name.
All right, Dr. Justin Yuko.
He was just retained as well, Your Honor. He's in the process of being retained more properly. He has not been formally retained yet, but as a precaution, we added his name right now.
All right, Tony Valenzuela.
There is a statement of Mr. Valenzuela attached. We added him now only as a precaution. It is not clear that, in fact, he'll be called as a witness.
Ms. Clark.
I've never heard it before today. This is the first, and of course, portions of these statements are blacked out as well.
Another issue. All right, Bethy Vaccarano.
There's a statement included in the packet from December the 8th, Your Honor. Deals with character matters and the relationship between Mr. Simpson and his former wife.
All right, Ms. Clark, are you acquainted with this name?
No, Your Honor.
All right, Dr. Lenore Walker. I take it you're acquainted with Dr. Walker, or her body of work at least.
Well, we know who she is, but of course we don't know what anything she's done in this case.
All right, but given Mr. Douglas's representation that she was recently retained, has not yet completed a report, I think that's the status of, we understand the context of her involvement here.
Correct.
All right. Chief Willie Williams, I think we're all acquainted with him. And Mr. Douglas, do you have a significant offer of proof that would cause Chief Williams to be a relevant witness to this case?
Your Honor, we did it as a precaution. It is likely he will not be called, but I did not want to be precluded.
Okay. Paul Willis.
He is an employee of the county coroner's office. There is no statement. There has been no interview.
Ms. Clark.
Surprise, we don't know who he is. Never
All right.
seen the name before.
Dr. Bernard Udovitz.
He is a doctor whom we have only recently retained, who has not yet finalized a report.
With respect to what?
All right. I take it, Ms. Clark, you don't know, you're not acquainted with Dr. Udovitz.
Not at all.
All right.
There are only a few, it'd be easier to count the names that we are familiar with on this list than the ones that we are not. Not to mention the additional fact of representations of counsel that no reports were prepared, although interviews were conducted. There's a case directly on point regarding that.
That's a different issue.
Right.
The issue at this point is what sanctions are appropriate at this stage in the proceeding.
With regard to sanctions, whether it be characterized as a sanction or just something reasonable under the circumstances, the people are asking for a week's continuance. This was thrust upon us and only upon request today. We want to see, we want to see what else they've got. We've got to check this out, Your Honor. And to get this today is just shocking to me. We would like a week's continuance so that we can digest this, take a look at what we've got, and then be able to react accordingly.
Not only that, Your Honor.
Well, wait. Mr. Hodgson, one of the things that I have on my checklist of things to do here is that we're going to have one counsel per side per issue on these matters from henceforth. Too bad I didn't get there first today. Mr. Cochran, good morning, sir.
Good morning to you, Your Honor. Having said that, perhaps I should sit down, since you have one counsel per side. I guess I'm going to be two here. I was just going to address the issue of the continuance, but perhaps that's not necessary at this point.
No, Mr. Hodgman, you're asking for something relatively unusual at this point. Do you want to elaborate as to why you feel the people should be entitled to a good cause continuance today?
Yes, Your Honor. As we have one speaker, may I have just a moment with counsel? I have some things I would like to say, but
Certainly.
let's make sure we get it all.
Mr. Hodgman.
Thank you for indulging me, Your Honor. Your Honor, we're asking for a continuance because it is reasonable under the circumstances, and we are offering that as an alternative to perhaps more severe sanctions that the court may entertain vis-a-vis the defense. The problem is exacerbated, Your Honor, because, first of all, let me say this. When there's a failure of discovery, one of the available sanctions is a continuance to allow the party who is harmed a reasonable opportunity to check out what they have just discovered. In addition, the problem is exacerbated this morning because we already know from representations from Mr. Douglas, or lack of knowledge on the part of Mr. Douglas, that there is other information that they possess that they have not been forthcoming with. We have asked today to have all witness statements, anything they've got, turned over. They've got photographs, they've got video, they have statements. Mr. Douglas alludes to perhaps investigators' notes. The problem is, Your Honor, what else do they have that isn't even on this list? The people have a right to know. It is apparently there. The people have a right to know, and that's one reason we're asking for a continuance so that we can flush out whatever it is they have, and then secondly, we have a reasonable opportunity to deal with whatever they have. I mean, to spring this on the date of opening statement is simply not fair.
Well, Mr. Hodgman, let me ask you this. My guess is that the prosecution will take at least 2 to 3 months to present their case in chief. That's a long time between now and the defense opportunity to present their case. Isn't that, given the rather iffy nature of some of these people, the representations as to who they are, isn't that sufficient time for the prosecution to interview these people or at least evaluate what's going to happen there, assuming I grant a preclusion of use of surprise witnesses for purposes of opening statement by the defense?
Okay, perhaps for some of the witnesses, Your Honor. However, again, discovery is supposed to be a reciprocal process. We are here on the date of opening statement, and as the defense has relied on...
There's nothing magic about today. It could be tomorrow.
Only in this sense, though. Only in this sense. You know, the defense has relied upon the discovery, which we, as the court is aware, you've heard the numbers all too often, which we have churned out on an unprecedented basis. We come to court today disadvantaged because of information which we should have had that has not been provided to us. It could affect how we present our case. It could affect, because if discovery is an engine for determining the truth, there may be information that is of relevance, of vital relevance to how we proceed with our case. We are here today to proceed with a statement of theory, a recitation or synopsis of evidence that we anticipate presenting, and we are hamstrung by the fact that perhaps part of the available truth which should have been given to us has not been given to us. I am concerned about this witness list, and in a reasonable amount of time we can deal with this. What I'm more concerned about, and what I'm asking the court for right now, is an order for the defense to disgorge whatever else they have. There appears to be some confusion that they're not even sure what they have at this moment, but it is very apparent, and I think the court realizes that they have more than what they turned over today. And at the very least, I'm looking at 2 aerial photographs taken some time before, photographs which have been in the possession of the defense, which should have been turned over to the people. There has been videotape shown this morning, which has been in the possession of the defense for God knows how long, which has only been disclosed to the people this morning. And I am reminded, some of this information absolutely pertains to our opening statement. So, Your Honor.
Such as, why don't you bring me into that context with your comments? How does this late disclosure impact your opening statement?
Your Honor, there's a videotape of the crime scene. I did not have an opportunity to observe it during the break because I was dealing with Mr. Douglas and other issues. But I'm advised there is a videotape of the crime scene, which I have not seen, which comes as a complete surprise to the prosecution this morning. And apparently it has been in possession of the defense and has never been turned over. And yet this morning, the defense, or today, or when we get to it, the defense wants to be able to utilize that tape. We haven't had an opportunity to even see it until today. We could have, even last week would have been helpful to us, but in terms of posing objections, in terms of anticipating defense remarks in opening statement, in terms of plotting our own opening statement itself, we should have been aware of this. There is an effect. There's a direct nexus between what they have withheld and what we may or may not have done, or what we can or cannot do today.
All right, Mr. Hodgman, is your primary objection the videotape at this point? I mean, the aerial photographs here, as I can see them, is there anything surprising to you about those items?
Your Honor, with regard to the aerial photographs are aerial photographs. What surprises me is the fact that they have been in the possession of the defense, again, for who knows how long, and yet we see them today. The aerial photographs we can deal with. The videotape is a different issue, and I have not even had an opportunity because during the break that the court afforded us, there were a number of issues that became that arose, let's put it that way.
That's why I
Now-
had asked, that's why I had scheduled 2 previous show and tells.
And we showed up Friday, and we showed, we told, and Mr. Douglas indicated that there would be a few things. And I have a list of things that he said would not be available as of last week. And we had no reciprocity in that exchange. They have come in with a multitude of hardboards, exhibits that they wish to use, and I'm putting aside just objections, I mean technical objections that should be made, that we've never even seen before. But of critical importance to opening statement are the witness statements. The witness statements which, again, they exist or they don't exist. There is something that they have not given us. What they have given us this morning, we've just become aware of this morning, Your Honor. So it's a matter of fairness. It has an impact on what we intend to do. The truth, or part of the truth, has been hidden from us by the defense.
And do you think it would take you a week to evaluate this and make it right?
Your Honor, we're asking for a reasonable continuance under the circumstances. I would say at least a week to take a look at what we've got. What concerns me is what we haven't received. And I don't know. I can't address that until we receive it from the defense. I can only ask the court to order the defense to disgorge what they have so we can have an opportunity to evaluate it.
All right, thank you, Mr. Hodgman. Mr. Cochran.
Always a pleasure to appear. Your Honor, if I might just say this, we used this word before, but I am absolutely appalled that the prosecution would come here and claim they're not ready for trial. They've been talking for months about all this mountain of evidence and how they're ready for trial. They see a few charts by us, and they become frightened and want to run away and hide for a week. And, Your Honor, Mr. Simpson is not going to waive time. And may I make this suggestion? I think that we're all trial lawyers here. They are not going to be able to get inside my head as to what I can say to this jury or my theory of the case. They can speculate, the pundits can speculate, but they don't know, Your Honor. And with regard, I think Mr. Douglas correctly pointed it out. How surprised are they, Your Honor, that we put on a list Kathleen Bell? We've been talking about her, and the court's aware, since the Pitchers motion. That's not a surprise. Many of the other witnesses, Your Honor, like Dino Baccola, we haven't talked to him yet. But when we talk to our client, and he says, look, the things they're saying about the Red Onion are flat out not true. We say, well, Mr. Simpson, who else was present? He says, Dino Baccola and the others. You talk to them. because you ruled just last week, we haven't had a chance. Out of an abundance of precaution, Your Honor, what we have done is to put a list together, as you saw. Many of these people may or may not call, but we tried to do that based upon what you're talking about. I have no objection to sitting down with my good friend Bill Hodgman or having Mr. Douglas do it right away and going through these things and disgorging any discovery they think they're entitled to. But the point is, Your Honor, they're not going to be privy to what's in our heads about what we think happened. They have their theory, we have facts, we believe, and they know the facts just like we should know them. And the fact that we have an aerial photograph, Your Honor, first of all, until we sit down, as the court's was a former trial lawyer, until we sit down over this weekend and work all night Thursday night and Friday night and then make a decision as what we're going to do, that didn't become even relevant. But I don't see how they're prejudiced about aerial photograph. They have them themselves.
Well, Mr. Cochran, the only real objection that I hear coming from the prosecution is the names on the witness list that they're not acquainted with and the videotape sequence that was just exhibited to the prosecution this morning. That's what I'm hearing. And I have to tell you, my inclination at this point is to deny the motion to continue, but to preclude you from using in your opening remarks any of the statements made by any of the witnesses that were unknown to the prosecution prior to today, and not to use them until they've had the opportunity, the same opportunity that you have for their new witnesses. That's my inclination.
In your own wisdom, Your Honor, I certainly can live with that. Let me first endorse the first part of your inclination, not for continuance. And with regard to the other people...
But I am going to afford the prosecution time over the lunch hour to sit down and go frame by frame over that video that you've just brought in, because I saw it flashing by too, and it appeared to me to be a composite of several different types of footage.
And, Your Honor, certainly, I think that's absolutely reasonable. And although the world awaits the opening statements, I think that
I don't
it's
care
not going
about
to...
that. I don't feel the pressure of
No,
time.
I'm saying I was going to say the
nor should
same
you.
thing. And I don't think we do either from that standpoint. The world may await this. If they need some additional time to look at the graphics, I think it's of their crime scene, Your Honor. So how big a surprise could this be to them? So we have no objection to that. And I was just going to suggest that on the discovery issues, if you allow us by the end of the day, I'm sure that Mr. Hodgman will be satisfied with regard to everything we have. We'll have each of the investigators down here to make sure there's no report we don't know about, and we'll discuss that. I mean, I think clearly we can do that.
All right,
It's not been an issue.
there's one hybrid problem that we have here. Certainly, the prosecution is not surprised to see the name Kathleen Bell, but they're perhaps surprised to see a new statement or statements of her or about her. That's the only hybrid issue that we have.
And we will address that issue also, Your Honor. I think, and also there's another motion today, a proffer that Mr. Beatty will be handling that will bear on this particular issue, it seems to me also. So I think that we can revisit that if that's all right with the court.
All right, I have on my agenda what I call Furman 2, which is new issues on that, new
Yes.
argument on that issue, or your new offer of proof on that issue.
Yes, Your Honor. Thank you, Your Honor.
All right, just so we're clear, the court's ruling is as follows, and I'm going to accept Kathleen Bell because I want to hear the argument as to the other part. The defense may use in their opening statement Mr. Glorioso, Mr. Matsuda, Dr. Paley, Claudine Ratcliffe, Rolf Rokar, Tracy Savage, Ron Shipp, Mark Stevens, and Dr. Lenore Walker. The remainder of the names on the witness list may not be used by the defense in their opening statement or referred to until the prosecution has had the opportunity to conduct reasonable investigation as to these persons who were just now disclosed the morning scheduled for opening statements. This list will be marked as Court's Exhibit 1 for the purpose of this morning's hearing.
Fine, Your Honor.
Mrs.
We
Robinson.
understand. Thank you, Your Honor.
With respect to Mr. Matsuda, I think, let me remind the court that there was an interview conducted of him by Mr. Pavlik some months ago, and it has not been ever turned over to the prosecution,
How do we know that?
because we asked Mr. Matsuda. We contacted Westech, and they informed us that there was probably more than one interview, and it occurred some time ago. It was lengthy in nature. There's no report that's ever been turned over to us.
I can represent, I'm not aware of it. It's one of the things that we get Mr. Pavlik available, as I suggested to the court. We'll have a meeting between Mr. Hodgman or Mr. Douglas, whomever, and go through those things with Pavlik. We have no problem.
All right.
See, but that's the problem, Your Honor.
Counsel, at the close of business today, I will sit down with you, defense counsel, court reporter, and we will go through these issues one at a time for discovery purposes. We will conclude this afternoon.
The problem, Your Honor, is there may be issues that we want to address in our opening statement pertaining to some of these witnesses, particularly domestic violence witnesses. And how can we possibly do so effectively if we don't even know what they said? Counsel has refused to turn over any statements made by them. We only today discovered their names, and they have not even reduced a lot of those statements to writing, which the court knows the impropriety of that. So how can we present an opening statement without knowing who these people are, which we may want to address?
An argument, Your Honor. Can we have a meeting first and we can argue afterwards?
I'm only indicating that we don't need to get into counsel's head, as counsel has indicated. We have no desire to do so. Privacy issues are being respected here. But we do need to know, you're welcome, we do need to know what there is so that we know what we have to address in the opening statement. And we cannot meaningfully make an intelligent decision without knowing that. Counsel has deprived us of the opportunity to do so. Not only that, but the videotape that the court sees, there are a lot of issues of foundational showings concerning timing. Counsel springing all of these exhibits on us at the last minute, and I indicate to the court there's one we have still not yet seen, that's not even present in court yet, that contains a lot of misrepresentations of fact.
All right, let's bring up the videotape. Do we have the videotape available? All right. Can we do that frame by frame and scene by scene?
Yes, scene by scene, Your Honor.
All right. How many are in this sequence?
There's several, actually.
How many is several? And can we have you state and spell your name for the record, please?
Howard Harris.
Howard Harris, Your Honor. H-A-R-R-S.
I asked him to do that. Thank you.
I think he was not focused.
There's Howard. Oh, it's Howard, yes.
Thank you.
For the record, Your Honor, these are composites of news clips that are on laser disc and being brought up in segments by a barcode reader.
All right, Mr. Bailey, what is this first sequence?
This first scene is
Mr.
Detective
Scheck?
Van Adder, Detective Lang, I'm sorry, walking down the steps in Bundy, and the two people on the top steps are members of the coroner's office. The woman in the white shoes from the coroner's office, the man in the blue suit from the coroner's office, and both bodies, as best I can tell, are still there.
What is the significance of the time mark at the bottom?
How does counsel know who those people are?
Because I have looked
Wait,
through the
wait,
discovery.
Counsel, please don't interrupt me.
I'm sorry, I didn't mean to.
What is the significance
Your
of
Honor,
the
that's
timestamp?
a counter, and it deals with minutes, seconds, and frames.
Of this tape.
There are 30 frames per second on a videotape.
All right. And what is this sequence?
In this sequence, the two individuals from the coroner's office who were previously up on the steps are beginning to take away a body. Detective Lang, you saw there, and then the man who crossed the scene from the right-hand side to the left is Mr. Fung. He's carrying a paper bag that contains evidence. On the bottom screen, with her back to you, is Andrea Mazzola.
All right, next sequence.
That is Mr. Fung with the yellow evidence cards in his hand that he's placing down before they take pictures, presumably after the measurements. Those are detectives walking through the crime scene.
Your Honor, to clarify one point, you asked about the digits. Those were imposed as part of the news company's work. They were on there when we got them. It has nothing to do with anything the defense included.
All right.
This is a subsequent time sequence, it appears to us. Again, these are detectives walking through the crime scene. And the camera does a close-up, and if you see and look very carefully, that is a yellow ticket 107 representing one of the items that pictures were taken of. That's it. Do you want to show the stills afterwards? Just to be sure. I've seen everything. These we've shown to the prosecution before. These are still photographs taken off television. Hit the next one. That is a still photograph that we received from the prosecution. That is the woman from the coroner's office next to, at this point, Mr. Goldman, and those are gloves on his body. And that was shown to the prosecution. They saw that previously.
All right, what's the people's objection to the use of this in opening statement?
The problem that we have, Your Honor, is with the misleading nature of it. We don't know when each video was shot, what time of day. We don't know who the people are in the photograph, and the way that the video segments are put together, it's hard to tell which came first and which really came second. So it's very misleading, it's very confusing, and there is no foundational, there's no authentication in terms of foundation as to time, when it was done, when each segment was shot, which came first, which came second.
Right,
That's
this-
also the objection, by the way, I may as well put them all out there, to the photographs of the uniformed officer walking up the walk. We don't have any indication as to when that occurred. I think I know what the defense is going to argue, and that's the problem, is that there's going to be it will be very misleading. There needs to be at least, there has to be some foundational showing as to when those photographs were taken and when the videos were shot in order to make them relevant and non-misleading to the jury.
All right, Mr. Harris, on your catalog of defense exhibits there, what was the sequence that you just showed us?
Those are just crime scene videos.
No, but I need to be able to identify them for the purpose of the record.
Would have been number 51, 52. 54, 55, and 56. And we also showed you a series of stills, 57, 58, 59, and 60.
I think what we need, Your Honor, these are excerpts from a larger tape. So counsel, the defense has taken portions of a larger tape out of the context of the entire tape, and we need to see the entire tape in order to place it back in context to figure out what the flow of events was and when the events depicted in that video transpired.
Well, that would mean that any one of your crime scene photographs, I would have to see all 200 of the crime scene photographs to put them in perspective. Isn't that the same argument?
No, it's not, Your Honor, because we're talking here about an issue of timing. We're talking about when events transpired, and in order to put it into context, that's how, that's the only way we're going to know. What they have, I think, shown us here.
Well, I assume that during the course, obviously, the issue of the quality of the collection of evidence is clearly an issue in this trial, and I assume that during the course of the opening statement, Mr. Cochran, or whoever it is who's going to make the opening statement, will tell us the sequence in which these events occurred. As their offer to the jury, this is what they're going to prove, I assume.
I don't know if we can assume that, Your Honor.
Well.
It can be just shown as, it could easily be used to just show officers walking around the crime scene and saying, look how they acted at the crime scene, without ever really saying it. And the problem is that we need some good faith offer of proof to indicate their knowledge and ability to demonstrate, foundationally speaking, that that there's a time certain when the video was actually shot.
Mr. Scheck?
Yes. Your Honor, I think I gave a narrative. I can sit down with them. The way I figured out when those things occurred is I looked at the discovery, I looked at the police reports. Mr. Lang was there. He knows the order in which people arrived. We know when the reports say the coroner arrived. We know at the time, roughly, the body's removed. We know when Mr. Fung was taking out his things to measure, and that's how I was able to give this narrative. And that's how we're going to prove it up.
That would not be enough to make it admissible, though.
That's how we're going to authenticate it.
And Mr. Scheck, do you have the photographers who took these photos, these videos, and who can testify to the foundation for these things?
Yeah. If necessary to call them, but that's necessary for the foundation. I would assume Detective Lang is going to say that's what he did and that's him. But if it's necessary, we can call the photographers who took the pictures.
We can't resolve the timing issue with Detective Lang. That's why we need the photographer.
Oh, I think we can. He filled out reports. We know when the coroners were there. We know the sequence of events. We know when Mr. Fung arrived. We know when the bodies removed. We know when the things were put down. If it'll make it any easier, Your Honor, we'll eliminate the last still photographs of the detectives walking through the blood at the plainclothes uniform fellow, because that we would probably only be able to connect up in terms of time from the person who took the picture. I have my, so we'll take those out. But the other ones are absolutely understandable from the people who did the crime scene, who did the collection, who were there, who made out the reports. I have confidence that just in looking at the pictures, they'll know what they did.
The problem is that Detective Lang was working at the time. He wasn't there looking at his watch and taking notes at the time that he was doing what he's depicted in the video as doing. And we need someone who was shooting it to be able to tell us what time that was, that it was being shot. And obviously that's going to be very important in terms of the authentication of that video as being relevant to the arguments of counsel. There's a foundational gap here. Counsel can't take the witness stand and say, I figured it out from police reports, because even the detective who was there can't be precise as to exactly when he was doing what was shown in the video.
Well, counsel, isn't the issue, though, that the court has to resolve for the purpose of opening statements whether or not the use of these exhibits would somehow be fundamentally unfair or fundamentally misleading to the trier of fact? And it's the theory of the defense, I suspect, and forgive me, Mr. Cochran, for trying to get into your thought process this morning. But I mean, it's no secret that the defense intends to vigorously challenge the quality of the collection of the evidence in this case. I suspect that given what I know of these attorneys and attorneys on both sides, is that they will be able to lay a foundation for the date, time, and place that these videotapes were taken. I assume that that's going to happen. And I don't see any fundamental difference between a photograph that's taken at the crime scene by detectives, by photographers for the LAPD, or the news people who are across the street videotaping.
The difference is, first of all, I think that if we can't make the assumption that counsel will lay a foundation. We don't know. There's not even been an offer of proof as to how they intend to do that, other than to say that Detective Lang should know when he did things. But Detective Lang, who was working at the time, cannot say with any precision when certain things occurred. Number two, it's very different situation.
Well, counsel, let me ask you this. Number one, first sequence is Detective Lang with two coroner's persons there. We know when the coroners got there, so we know it's at least how many hours after the crime was committed? 10 hours. And we know that they're standing there at the top of the steps and that there appears to still be a body at the bottom of the steps. So we know the body has not been transported yet. That gives us a relatively good time frame, I would imagine. Then we have the coroner with Mr. Fung and Ms. Mazzola there at the crime scene. Since we know the coroner didn't get there until 10 hours after the bodies were discovered, that also, and we know when we know when Mazzola and Fung got there. We know that it's after that point in time, and they appear to be doing something. I don't know what argument or what offer of proof Mr. Cochran is going to make to the jury as a result of that, but at least we have some fix. Then I saw detectives walking through, who appeared to be walking through the crime scene. Appeared to be, I can't remember the name of the detectives, but I recognize who they were. And, I'm sorry? And there appears to be an evidence tag down at the bottom, or a photo tag down at the bottom of the scene. So we know when the photographer was using those to take pictures, doesn't that give us a reasonably accurate time frame to evaluate what's there?
No, it doesn't. And the reason
Why
it
not?
doesn't is because criminalist Fung was at Bundy more than once. They had to go back and forth between the scenes. We don't know how long the coroner was there before, how long they waited after they got there before they did anything. We don't, there's a whole lot of issues there, so we don't know when the collection of evidence occurred vis-a-vis the arrival of the coroner or the removal of the bodies by the coroner. No, it doesn't resolve anything, Your Honor, because there's a lot that's going on at that scene. It doesn't. And that's why we need to get the photographer and see if there's some record to indicate exactly when it was taken. Because what counsel has indicated to the court gives nothing more than a rough estimate as to, well, it had to be after 8 o'clock. That's all it does. That's all it does. It doesn't tell you whether it was before 10, after 10, before noon, after noon, none of it.
Well, when were your critical evidence samples collected?
There was collection at Rockingham at 7, and then collection began at Bundy at 10 to 10:15. You see the problem?
So what remedy are you asking for with results specifically to the videotape? Mr. Scheck has indicated they would withdraw the stills.
With respect to the videotape, the people only asked to see the entire videotape and to talk to the photographer, get a statement from the photographer indicating what time it was when that videotape began, and then a real-time counter to show the entire extent of the footage. That will resolve the issue, and we'll know exactly when it was taken, and there will be no issue of misleading or confusing the jury, which is what the people are concerned about.
Mr. Cochran, is this video from one source or multiple sources?
Best I can tell, Your Honor, is from one source, and I'd have to check to make sure so I can, be clear on that, Your Honor.
Appears to be a news photographer from across the street.
I think that's where it's from, Your Honor. And, Your Honor, the thing that's so amazing about this entire thing, this is a crime scene where we have witnesses. What counsel is talking about, Your Honor, doesn't go to admissibility. I mean, she may argue that regarding weight, but clearly this is admissible. This is her crime scene. Your Honor, if this crime scene had been conducted properly, they'd have a complete videotape of everything. But they don't have that, and that's one of the problems. And so, but I think you can argue about what second this took place, but Your Honor is correct. There are logs as to when people came. Detective Lang is experienced detective. He knows when he got there. Detective Van Etter knows when he walked through that scene with, I guess, Rogers. And I think that we will be able to do this. And what we're talking about is not admissibility, and nobody's trying to mislead the jury. This is their scene. I mean, we are going to, as the court has indicated, have some other things to talk about that particular area. But I think that we're willing to cooperate. They've seen it. She wants to see the whole thing. She's seen it. She can see it over the lunch hour. But, Your Honor, that has nothing to do with admissibility.
All right, Mr. Cochran, where is the full videotape?
It's now on this is very technical, Your Honor. It's now on some kind of a laser disc. May I inquire?